Hi, my name is Halia Stoyich, and I work at the Equal Rights Center. The Equal Rights Center assists individuals in the greater Washington, D.C. region, including the entire state of Maryland, who are experiencing possible housing discrimination. In Maryland, source of income discrimination is illegal, meaning that a landlord can't discriminate against you for having a housing voucher. With this in mind, we wanted to provide you with some information about your rights as you begin your housing search. The Federal Fair Housing Act makes it illegal nationwide to discriminate against someone in housing based on 7 traits, which are race, color, national origin, religion, sex, including sexual orientation and gender identity, disability, and familial status, or presence of children under the age of 18 in the household. Under Maryland's fair housing law, it's not only illegal to discriminate based on the 7 traits just mentioned, but also 5 additional traits, including marital status, sexual orientation, gender identity, military status, and source of income. This means that, in Maryland, it's illegal to discriminate in housing based on source of income. Source of income refers to any legal form of income that a person uses to pay part or all of their monthly rent, including housing vouchers. Examples of possible discrimination based on your housing voucher could include advertising statements like "No Section 8 accepted" or "We do not accept housing vouchers," landlords saying that you can't apply because they haven't gone through the approval process to accept housing vouchers, or charging you a higher rent or security deposit because you use a housing voucher. The Maryland Commission on Civil Rights, which enforces the state's housing discrimination law, released guidance in 2025 that further explains source of income protections in housing. One major concern we hear from renters with vouchers is regarding minimum income requirements. Many landlords require that applicants meet minimum income requirements of 2, 3, or even 4 times the monthly rent. If you have a housing voucher, the MCCR guidance states that landlords can only require that you make 2, 3, or 4 times your portion of the rent and not the total rental amount. For example, let's say you have a housing voucher and are applying to a property that costs $2,000 a month and has a minimum income requirement of 3 times the monthly rent. For individuals without housing vouchers, the landlord could likely require that they make $6,000 a month or $72,000 a year. However, it would be likely illegal to require that you make the same amount because you have a housing voucher. Let's say, in this scenario, your voucher covers $1,800 of the $2,000 rent, meaning that the portion that you're responsible for paying each month is $200. In that case, the landlord could only apply the minimum income requirement to your portion of the rent, meaning that they could only require that you make $600 a month in order to qualify, and not $6,000 a month. If the portion of rent that you're responsible for paying each month is $0, then a landlord likely can't deny you on the basis of any income requirements. Another common area of concern we hear from renters with vouchers is credit screenings. Landlords can generally consider your credit score or history, including charge-offs, late payments, and other negative items. The MCCR guidance states that landlords should consider an applicant's credit on a case-by-case basis to avoid discrimination when considering an applicant with a housing voucher. The guidance also says that if an applicant doesn't have sufficient credit, the housing provider should consider the applicant's housing payment history, bill payment history, and similar evidence of the applicant's likelihood of paying rent on time. As such, landlords should conduct an individualized review of your credit and allow you to provide additional information that could help address any concerns that they may have about negative items on your credit report. This additional information could include providing a record of having paid rent and utilities on time. Lastly, if your entire rent is covered by the voucher, i.e., your portion of the monthly rent is $0, then it may be illegal for a landlord to deny you based on your credit. Another form of discrimination you may encounter during your housing search is based on your familial status or having children under the age of 18 in your household. Landlords sometimes refuse to rent to families with children, claiming that their units are too small. However, without getting into too much detail, generally speaking, landlords should allow a family of 3 to rent a 1-bedroom unit, a family of 5 to rent a 2-bedroom unit, a family of 7 to rent a 3-bedroom unit, and a family of 9 to rent a 4-bedroom unit. The ERC has also assisted multiple individuals in the region who have experienced potential discrimination related to criminal record screenings. While having a criminal record is not a protected identity under state or federal fair housing laws, criminal record screenings that disproportionately reject a particular group of people based on a protected identity, such as race or national origin, may be illegal. In Maryland, there are significant racial disparities in the criminal legal system, which means that people of color are more likely to be negatively affected by criminal record screenings in housing. Given this, it's likely illegal for a landlord to apply a felony or conviction ban when screening applicants, which means that a landlord shouldn't automatically deny every applicant with a felony or conviction on their record. It's also likely illegal for a landlord to reject an applicant based on an arrest that didn't result in a conviction. Instead, landlords should individually assess each applicant's criminal record and allow applicants to submit additional information regarding their criminal record, including what crime was committed, when the crime occurred, how long it's been since the crime occurred, the individual's age when they committed the crime, and any changes in their situation since the crime occurred. If you or a member of your household have been denied from a property because of the results of a criminal record screening, and the housing provider did not give you the opportunity to submit this additional information for consideration, that would be likely illegal. Lastly, people with disabilities have a right to request reasonable accommodations in housing. Examples of various disabilities include being blind, deaf, or hard of hearing. Other disabilities include mental health disabilities, such as depression or PTSD, and chronic health conditions, such as asthma or diabetes. A reasonable accommodation is a change or exemption to a policy or practice by a housing provider, such as a landlord or housing authority, to ensure that a person with a disability has equal access to and enjoyment of their unit. Examples of potential reasonable accommodations include having an emotional support animal in a building with a no pets policy, being assigned a reserved accessible parking space, a transfer to a more accessible unit, an extension to your housing voucher so you have more time to find housing, increasing your voucher size by 1 bedroom so you can have a live-in aid, changing the date of rent payments to match when a person receives their monthly disability income, or not considering a criminal conviction directly related to a person's disability. If you believe you may have experienced discrimination based on your voucher or based on another identity or characteristic, such as your race, disability, or having children under the age of 18 in your household, if you would like assistance with submitting a reasonable accommodation request, or if you have any questions about your fair housing rights, you can contact us at the Equal Rights Center. The Equal Rights Center may be able to directly advocate on your behalf with the landlord, assist people with disabilities with requesting reasonable accommodations in housing, and help individuals file housing discrimination complaints with the Maryland Commission on Civil Rights, or HUD. You can contact us via email at info@equalrightscenter.org or by phone, either call or text at 202-370-3224. Thank you.